Yeah, thank you, ladies and gentlemen. I would like to provide a legal analysis of Uganda versus Christopher Okello, Onyum, in light of the just concluded case. It will be more like a critical examination of the procedural correctness and the evidentiality findings and how what the court probably relied on, and what are the strengths, what are the weaknesses, what would be the takeaways. It's more like an evaluation so that we can have an analysis in terms of the law predominantly, but more importantly in terms of how the ordinary person may appreciate the context of the case. So I will once again say good evening to you. Tonight, as I said, I will examine one of the most disturbing criminal cases in recent history, the Uganda versus Christopher Okello Onyum, decided by the High Court sitting at Gaba in light of the mobile court on 30th April. This was a tragic case involving the brutal killing of four innocent, aged between 3 months and 2 and 6 months at a daycare center. Naturally, such a case would invoke public anger, grief, and even demands justice. But the law must rise above emotions, and this is important. So the central legal question is not whether the crime was actually horrifying; it undoubtedly was. But the true legal question basically would be: was the conviction reached through proper procedure, sound evidence, and constitutional fairness? That is important as well. So tonight I will offer critical legal analysis in what the court got right, what may be challenged on appeal, and whether the conviction remains legally safe in terms of legal jurisprudence for purposes of sound criminal procedure. So I will argue them in light of parts, and I'll begin with part one. And in part one, I'll argue in terms of what the court got right. Can we analyze, can we put to bed what the court got right? Now, in trying to analyze that, I will do the following. I will analyze whether there was a correct application of the burden of proof, and this is important in criminal procedure. So the court obviously correctly followed the golden principle in criminal law established in Wilmington versus DPP. The prosecution must prove every element of the offense beyond a reasonable doubt. Now, when the defense raised insanity, yes, the judge properly shifted only the evidential burden, not the legal burden, to the accused. Now, the defense was only required to prove insanity on a balance of probabilities as established in Nyenge, son of Suwatu versus R. So this obviously was a textbook application of criminal law principles, and that is something we have to understand. The part of the judgment was doctrinally sound. We also can agree to that fact, that the part of the judgment was doctrinally sound in that respect. Number two, was there a proper application of the Magneton rules? Now, the court also correctly applied the famous Magneton rule, which remains the legal test for insanity in Uganda. Now, for purposes of a succession is succeeding, to succeed, the defense had to prove the defect of reason, okay, and then the fact that it was caused by a disease of mind, and that the accused did not know the nature of his act, or that it was actually wrong. That is important as well in terms of understanding that. But the evidence showed otherwise. Yes, so the accused managed mobile money transactions. He operated bank accounts. He hired and even drove a vehicle with full awareness. He lied coherently about enrolling a non-existent child. He even called police for protection after the killings. These are not actions of someone who did not understand what he was not doing. The court was therefore right to reject the insanity defense. Okay? We will go piecemeal, part by part. Let me go to issue number 3, the aspect of the strong proof of malice aforethought. The argument here would be that the intent to kill is rarely proven directly. The courts infer it from surrounding circumstances. Following, for example, Ara versus Tubere, son of Ochen, the judge properly considered that aspect. The use of a sharp kitchen knife is also something that was also considered. Repeated targeting of the neck, then the movement from one child to another methodically was also established. And then the aspect of the prior Google churches in terms of searches of ISIS beheading. So then the visit to the daycare centers before even the attack. And the possession of Sun Tzu's book, The Art of War. Also, all those who are fundamental in the concept of trying to analyze this. So they were not random acts. We cannot say that they were random acts, no. They strongly pointed to preparation, to planning, and to a deliberate execution. Okay? And this was sufficient evidence for malice aforethought. Okay? I'll go to issue 4 in the context of still of the case as it played out. The aspect of the correct rejection of diminished responsibility. The accused also argued diminished responsibility under section 194 of the Penal Code, claiming that sickle cell disease impaired his judgment. But the law requires proof of a direct causal connection between the mental abnormality and the killings. So medical experts testified that the chronic illness may cause depression. There was no psychosis, no mental collapse, and no evidence linked to sickle cell disease in light of the slaughter. And therefore, without that legal nexus, the defense must actually fail. And the court was again right on that particular point. Okay? I will take you again through issue number 5 in terms of the proper use of the mobile court, because it also came as a question of legality. So initially, Uganda Law Society criticized the mobile court, fearing it would actually become a judicial theater or perhaps a public vengeance disguised as justice. Yes? And I was partially one of those who raised an alarm in that context. But the judgment obviously shows something important. The judge remained controlled, wonderful demeanor, disciplined, and evidence-based. We all probably saw that. She actually rejected irregular applications and even focused strictly on law, although we shall argue the aspect of procedure at a certain time in terms of procedure challenges. So a mobile court is not automatically unconstitutional if fairness is actually preserved. Yes? So the legality depends on conduct, not location. Yes? And that has been established in terms of that. So, my friends, in the discussion that I made, that has presented what I would have argued as part 1. I would like to argue part 2 in terms of the legal weaknesses and the possible appeal grounds that may ensue from this case. And this is where we're going to have a little bit of depth in terms of the analysis of the legal aspects. So the aspect number 1 would be the disputed confession without a voir dire. Yes, this is perhaps the strongest vulnerability. The judgment referenced that the accused had allegedly confessed during preliminary interviews. Yes, but he claimed coercion. Remember that. So under criminal procedure, once a confession is actually challenged as involuntary, the court must hold what lawyers call a trial within a trial, a voir dire. So the prosecution must prove that the confession was voluntary. The judgment does not clearly show that such a voir dire did actually happen. Okay? That omission creates a procedural vulnerability. However, because of the CCTV, the DNA, the eyewitnesses, and forensic evidence, they were overwhelming. So this error alone is unlikely to overturn the conviction. Still, in its legitimate appellate issue, you cannot take that away because of that procedural challenge. Aspect number 2 would be a failure to call certain witnesses. The defense, for example, argued that the first responders who physically arrested the accused were never called to testify. So this includes individuals like Cyrus, Moses, Bashir, and Timothy, as we saw them. So the prosecution is not required, by the way, to call every witness, yes, but a failure to call material witnesses can actually create room for adverse inference. That is extremely important as well. Now, obviously, this could be argued as a small evidentiality gap, okay, and not fatal in terms of that. Let us argue issue number 3 in context of part 2. The heavy reliance on earlier sanitary reports, for example. A December 25, 2025 psychiatric report declared the accused sane, yes? But insanity must be assessed at the exact moment of the offense. That was in April 2026, yes? So someone may actually be sane in December and psychotic in April. You must be very careful with that. So this makes a reliance on the earlier report legally imperfect in the context of what we're talking about. However, the court cured this weakness by relying on the accused's real-time conduct during and after the killings. So the contemporaneous behavior became stronger evidence than the old report itself. Okay? We promised ourselves to do an evaluation of the Christopher Okello Onyum case. Let's go to part 3 of my discussion. Part 3, in light of Article 28 and the right to a fair hearing, that is what we want to address in light of part 3. Was, for example, the mobile court constitutional? Obviously, this became a national debate, and that is something I want to argue in this part. The trial was held at Gaba Community Church grounds near the scene of crime with public screens. Yes? So critics argue that it violated Article 28 of the Constitution, the right to a fair hearing before an impartial court. And frankly, the optics were dangerous. Justice must not only be done, it must be seen to be done. So a courtroom must never resemble a public execution. However, the legal record shows that no proof that the judge surrendered to public pressure. She did a professional job, as we all observed. She convicted on forensic evidence, not on mob anger. So while the appearance was troubling, the procedural fairness inside the courtroom remained intact. We can bear witness to that, save from the rains that came. So future mobile courts can actually, in terms of capital offenses, will perhaps have better safeguards using this case as an example. So in light of the discussion that I've just presented, what was the final verdict? Was the conviction, for example, safe? My answer is yes. The conviction is legally safe, although there will be a but. You know, there is always a but. Why do I argue that it was safe? Because even if we remove the disputed confession, even if we ignore the early sanity report, the remaining evidence is still overwhelming. Yes? In light of the CCTV footage, for example, fundamental in terms of that. in light of the DNA on the murder weapon, you cannot hide away from that. In light of the eyewitness testimony, fundamental. And in light of the deliberate lies that were also proved. And also the multiple knives, for example. Yes, and the ISIS beheading searches, for example. And then the prior daycare visits, for example. So calculated movements, for example, also before and after the killings. All this was fundamental and showed a lot of culpability in terms of proving this particular aspect. So this was not confusion. This was preparation. Yes? This was not madness. This was not madness at all. This was a method, a diabolical method filled with malice aforethought. The rejection of insanity was, in my opinion, legally justified. Although there is a but, as I argued. So the proof of malice aforethought was overwhelming. The conviction for murder for all 4 counts was both factual and legally inevitable. We were a little afraid of whether or not justice would be ensured on this particular matter, given the excitement, the public excitement. We knew where it was going, but how was the question. So this case teaches us an important lesson. Yes, even where guilt appears obvious, procedure still matters. Now this is my but. So justice is not only about pushing the guilty, it's also about proving the guilt lawfully. In other words, courts must never say he obviously was guilty, so procedure does not matter. No, that should never be the case. Procedure is justice, incidentally. And where a confession is disputed, a voir dire must always be conducted on record. That protects both the accused and the legitimacy of the court itself. This or that is how justice survives emotion. That is how the law survives outrage. And that is how constitutionalism survives tragedy. I thank you, ladies and gentlemen. God bless you, and thank you for your attention.